telling you, I'm embarrassed in front of my client. I'm embarrassed in front of the court. And, I've seen there's members of the press here. I'm embarrassed. This is, by hitting me with the appropriate sanction there, the attorney fees, I am deterred. I admit that I should be sanctioned for the attorney fees. And that should be the only sanction in this court.
All rise, please.
Good morning, please be seated. Vote.
Yes.
TRT 01, Gilman versus Toll. This is the time set for hearing on in order to show cause.
Your Honor, I'm going to log back in because I can't hear.
Is that any better?
I'm hearing broken, Your Honor, so I'm going to just try and log in and see if it's a better connection. I apologize.
Mr. Gilman, are you able to hear me?
Yes, Your Honor, loud and clear.
Where are you located?
In Florida?
This is being recorded on the court's recording system. We'll wait until Mr. Flangas gets back on. Mr. Toll, dear Mr. Busby, correct?
Yes, sir. Good morning. I'm hearing for the plaintiff, Sam Toll, Luke Busby, and my client.
Our present in the courtroom.
Good morning, Your Honor. Let me see if I can hear y'all now.
Can you hear me now?
I'm not getting any audio. Again, Your Honor, can someone call me on my cell phone and I'll mute it from this end.
All right. What's the cell phone number? You can't call him, right?
Yes.
I just got a text. My cell phone number, Your Honor, is 702.
Hello, Mr. Flangas, the judge.
Is the recording going to pick that up?
You might need to put it a little closer to the speaker.
You can hear me okay now, Mr. Flangas?
Yes, Your Honor, I can hear you through myself.
Say something again.
Mr. Flangas, where are you located today?
I'm in Las Vegas at my home, Your Honor.
Yes.
This is being recorded on the court's recording system. Mr. Busby?
Good morning, Your Honor.
Good morning. What is your position in light of the defense's response?
Our position is that the court should still make a finding of contempt, assess the opponent's attorney's fees on the basis of that contempt, and issue default judgments, in my opinion, based on Nevada Rules Civil Procedure 37B. And if I may, Your Honor, I'd like to...
Hold on just 1 second. Mr. Flangas, are you able to hear Mr. Busby okay?
I'm not hearing him at all, Your Honor.
Would you go ahead and have a seat and speak towards the microphone? And hear me now? I'm sorry, but I'm going to have you start from the beginning. Go ahead.
Okay. Your Honor, it's our position that the court should still find Mr. Gilman contempt for failure to comply with the court's order, that the court should issue as a sanction of that contempt an award of attorney's fees for essentially my time in having to pursue this matter, and award default judgment to my client under Nevada Rules Civil Procedure 37B1. And just for the record, Your Honor, I believe it's the case that Mr. Gilman has failed to comply also with the court's order to show cause, directing him to appear today before this court to address this order to show cause, so why he should not be held in contempt of court. The order was unambiguous. It required him to appear. There was no exception allowing telephonic appearance. All that was filed was a notice of telephonic appearance.
Hold on just a moment. You're not able to hear him?
Not at all, Your Honor.
And Your Honor, this is precisely the, one reason why in person.
Hang on, so that he'll be able to hear you. Got any ideas?
I do not.
Were you on a landline before, Mr. Flangas?
No, I signed in on Zoom and put, all I'm hearing is gibberish coming through the speakers on Zoom, and then I had telephone, my, cell phone. And so, no, I wasn't on the landline.
Do you have a landline we can call?
Yes, I do. It's, 702.
We're gonna try that number.
Thank you.
Can you hear me okay?
Yes, I can hear you fine.
Mr. Busby, will you, I'm sorry, start over again, but only about the first sentence, and then I want to check to see if he can hear.
Okay. Your Honor, at the outset, we believe that there's some.
No, I'm still not here, and I apologize, Your Honor. I don't know what's going on with my systems here, but I've done hundreds, quite a few Zooms from this. And I'm not even sure the rest of my, I don't think my clients are hearing Mr. Busby either.
Mr. Gilman, are you able to hear Mr. Busby?
Neither.
I'm sorry, Your Honor, it's very light, it's hard to distinguish, all of the words.
What would you like me to do, Mr. Flangas?
Can we take a brief recess and I'll run over to my office?
How long will that take?
About 20 minutes.
Mr. Busby?
Your Honor, we object. The court's order again clearly commanded Mr. Gilman to appear before this court. He's failed to do so. This is a serious matter. It's an order to show cause why he should not be held in contempt of this court. Mr. Gilman's counsel did not obtain leave from the court to appear telephonically or by Zoom today. Personal attendance is required if that leave isn't provided. He's in violation of the court's order, and the court shouldn't indulge.
Your Honor, let me try one more thing here. Let me see if I can, let's see if I can pick it up on my home computer while I'm here.
All right.
Just give me a moment. Your Honor, if I can get 20 minutes to get to my office, I'll have another system set up.
Let's try this. I'm going to repeat what I understood Mr. Busby to tell me. I understand, Mr. Flangas, that you can hear me okay. Is that right?
I hear you perfectly, Your Honor.
And Mr. Gilman, you hear me all right?
Yes, Your Honor.
Mr. Busby indicated that their position is that I should find Mr. Gilman in contempt, award Mr. Toll his attorney's fees, and enter a default judgment against Mr. Gilman. Did I cover everything?
Yes, Your Honor, except that we have some default to be entered under Nevada Rules of Procedure 37, not the contempt power of the court.
So he's asking for an entry of default under NRCP 37. He also requested that I hold Mr. Gilman in contempt for failing to appear at the hearing this morning. I didn't have a chance to ask him, so I'm asking you now. There was a notice of intent to appear by communication equipment filed here yesterday at 11:10 a.m. Did you get that?
I did receive that, Your Honor.
Anything you want to tell me about that?
I object to that, Your Honor. In order to appear telephonically or by Zoom, leave of the court is required. On, I believe, May 13th, under administrative order, the administrative order issued by the court is reopened. That administrative order specifically states that leave is required, a request is required to appear telephonically. It also got rid of the system for filing electronic documents. It basically reopened the court, Your Honor. And so the normal rules of procedure apply. If you'd like to appear by Zoom or by telephone, you have to request leave from the court to do so. None was done. an assumption was made on the part of Gilman's counsel that he could appear by video today. This is a serious matter. We would have objected to any motion. All that was filed was a notice. We want Mr. Gilman to appear before this court and explain exactly why, through his counsel or otherwise, he would disobey a court's order, ignore multiple motions that we filed trying to compel his response to our interrogatories. And the problems that we're having today are indicative of why that objection made sense. This is a complicated matter. It's a serious matter. We're asking a public official to be held in contempt. And it's clear by their response that they're still not taking the matter seriously. So we would ask the relief requested.
Mr. Busby objects to your notice of intent to appear by communication equipment. His argument is that to appear by communication equipment requires leave of court. You did not obtain that. You did file yesterday morning the notice, but leave was not granted. The notice was not timely. And so they, Mr. Toll, Mr. Busby, want Mr. Gilman to appear and explain why he should not be held in contempt, why it's required multiple motions to try and move this forward. Mr. Flangas?
Thank you, Your Honor. We emailed that intent to appear electronically on Wednesday. We were in contact with your office all day yesterday, and what we were basically told is it was either going to be phone or Zoom. If it was even told that we couldn't appear, we would have definitely done whatever it could to make the appearance there. Your Honor, as to the underlying motion on this, I made it abundantly clear to the court, as an officer of the court, as a longtime attorney, and as somebody whose word is good, that I take full responsibility for what occurred in this matter. Mr. Gilman had nothing to do with it. We and myself, I know a lot of attorneys will come into a courtroom and will try to blame their staff on everything for what happened. I'm coming in because I know whatever happens with my staff is my total and full responsibility. I take the full responsibility for this. Mr. Gilman, again, had absolutely nothing to do with the failures in this. The failures, as I put my paper to you, it's not to make a huge excuse, but was to explain what occurred and to show that what we did was not intentional. What occurred in this, as I pointed out in my papers, was a cacophony of errors going back to the beginning of this year. My court counsel on this case got elected to the bench. She would want to track a lot of this stuff. That's not the big excuse, and it's really not. A while later, I ended up contracting COVID. I was out of the office for a little over a month. I was, for 3.5 weeks, fighting staying out of the hospital every day, so I wasn't getting much work done. We got way behind. Didn't factor in that I had an issue with an office manager who didn't give me a calendar. That's still my responsibility, but I just wanted to put this out. I had some family issues in between, 2 deaths, and some internal issues that also fully impacted my abilities in to perform fully to my full potential in my office. Your Honor, I'm not making excuses. I'm just trying to explain, but I want this to be abundantly clear. And I'm here, essentially admitting complete and utter fault on my part. I'm not doing it to save my client or anything else. It is totally 100% me. My client should not be found in contempt. My client should not be sanctioned. My client, anything that occurred in this, any sanction should go to me and me alone. Your Honor, because he mentioned that a default should be entered in this case, I put forward in my moving papers the factors, before the factors that need to be addressed before any type of case and sanction can be entered. I put forward all the factors coming from the Gilman case, which, as courts well aware, that's the seminal case on these things. I think I addressed the degree of willingness willingness of the offending party is one of the 8 factors. There was no willingness on the part of my client. Clearly, there was no willingness on my part whatsoever either. It was just straight, plain flat, we screwed up and nothing else. I can't even overemphasize this enough. The second factor is the extent to which the non-offending party would be prejudiced by a lesser sanction. There's no prejudice to Mr. Cole in this case if you were to find me as a sanction for the attorney fees whatsoever, because he can still go forward with this case. This has not really delayed the case more than just a couple of months. Quite frankly, there's an appeal pending before the Supreme Court that could make this all move anyway. But here we are. There's nothing that would prejudice Mr. Cole by allowing this case to go forward and sanctioning me. It would make him whole on his attorney fees. The third factor is the severity of the sanction of dismissal relative to the severity of the discovery abuse. The sanction of dismissal or case-ending sanction is very severe in this type of case. The failure on my part was to fail to answer interrogatories that effectively amount to a debtor's exam is what they really are. With that said, Your Honor, the sanction of dismissal or case-ending sanction is too severe relative to the discovery abuse. The fourth factor, Your Honor, is whether any evidence has been irreparably lost. There's absolutely no evidence that's been lost whatsoever. I can't even imagine you might point to any lost evidence in this matter. The fifth factor is the feasibility and fairness of alternative less severe sanction. And in this case, the fee is the award of his attorney fees to appropriate sanction. The policy, which is number 6, of adjudicating on the merits, is of course well aware the Nevada Supreme Court favors cases being decided on the merits. There's one factor in this case, and again, there's no prejudice or anything. Mr. Gilman should be allowed to go forward on this case, and to do otherwise would be pretty contrary to the state's underlying basic policy. The seventh factor is whether sanctions unfairly operate to penalize the party for the misconduct of his attorney. Your Honor, I did this, nobody else, not Mr. Gilman, myself and my office, and we accept it. I'm here before the court. I'm not comfortable doing this. I don't find myself in this situation ever, and here we are. The 8th factor is the need to deter both parties in future litigants from similar abuses. Your Honor, as I've stated over and over just throughout through my brief and through my remarks here, the fault lies with me. I can guarantee you this isn't going to happen in the future. I'm telling you, I'm embarrassed in front of my client. I'm embarrassed in front of the court. And, I've seen there's members of the press here. I'm embarrassed. This is, by hitting me with the appropriate sanction there, the attorney fees, I am deterred. I admit that I should be sanctioned for the attorney fees. That should be the only sanction in this court. And I would just add that fundamental notions of fairness and due process require that the sanctions be just and relate to the specific conduct at issue. Being here today and finding me with the attorney fees clearly is a just sanction, and it would specifically relate to my conduct in this case. And again, I emphasize my conduct, not my client's conduct, mine and mine alone, Your Honor. I'm a straight shooter. I didn't come here trying to make a bunch of excuses, Your Honor. I'm here telling you this is my fault. With that said, Your Honor, I would ask that you not find Mr. Gilman anybody in contempt, and just I'll submit to the attorney fees, reasonable attorney fees, sanction on me.
court has a few comments before we begin.
We are on the record in the matter, case D 505.
You guys either agree or I order.
I don't hear anyone saying she can't order a change of custody if she follows the right procedure.
Must be an aggravation.
You're going to convince me to hold your client in contempt.
Raise your right hands, face the court clerk to be sworn.
Even judges get contempt wrong all the time.
Go ahead.
Yes, sir. If I may.
So I need you to kind of chunk it up because I'm going to summarize to him.
Okay. At the outset, I want to talk about procedural history because there's some things that Mr. Flangas got wrong. This is a slap back case being conducted under NRS 41671C, and it gives Mr. Toll the right to sue Mr. Gilman for punitive damages because Mr. Gilman filed a frivolous slap case against my client to try and press his First Amendment right to free speech on an issue of public concern. He sent the interrogatories on May 17th, and on March 31st, the court granted summary judgments in favor of my client on the issue of liability. So the only outstanding issue is damages. All of the interrogatories requested relate to damages only. So they're relevant, and they're an outstanding issue in the case. Punitive damages are specifically provided for under NRS 41671C2, and we have demonstrated a factual basis for the punitive damage claim based on the statute and by prevailing on the summary judgment motion. Now, we've sent Mr. Flangas, I think, 11 or 12 meetings in this case on this motion. We issued the interrogatories on March 17th. His responses were due April 16th. On April 26th, I sent him a meeting for email to which he did not respond. We filed a motion to compel on May 3rd, 2021. He did not respond to that. On May 21st, 2021, we submitted the motion to compel. This court issued an order directing compliance to Mr. Gilman on May 27th. We issued a notice of entry of order on that same day. On June 9th, we filed a motion for an order to show cause regarding the contempt for complete failure to respond to the court's order. Didn't respond to that either. We submitted that for decision on June 28th. On June 30th, the court issued its order to appear and show cause. And on that same day, we issued the notice of entry of order. Now,
let's just go that far. Mr. Busby has argued that he wants to review the procedural history because he argues, Mr. Flangas, that you've gotten some things wrong. He's reminded the court that this is a result of a SLAPP lawsuit, that Mr. Toll is suing for punitive damages. That summary judgment was issued on March 31st, so the only remaining issue is the amount of damages, and that Mr. Toll has been forced to file a number of pleadings in connection with the interrogatories, including a meet and confer letter, motion to compel, the request to submit, notice of entry of order, and other papers. Go ahead.
Your Honor, now, in Mr. Flangas' response, to the order to show cause, which was filed with the court extremely late. He could have responded to our motion to compel. He chose not to do that. Instead, he waited until the last minute to present a voluminous objection, basically to our motion and the court's order to show cause. The response is a fugitive document. The court never requested a response. It ordered Mr. Gilman to show up here in court and to explain why he should not be held in contempt. He's failed to do that. Now, the excuses provided by Mr. Flangas in his response are his partner resigned. Well, this happened in January of 2021, 7 months ago. That's not a reasonable basis for failing to respond to pleadings that were mailed to him over and correspondence over months and months. Now, Mr. Flangas had COVID for a month. I sympathize with him for that. Okay, but that's 1 month. This, again, the course of this problem has been occurring for months and months. He has internal family issues. Well, I sympathize with him on that point as well, but we all have personal problems, and we can't rely on those personal problems to intercede, and overcome our professional responsibilities. Now, he also claims he was preparing for an extensive FINRA arbitration matter. Well, that belies his previous explanations, Your Honor. If he thinks that the FINRA matter is more important than this matter, fine. He has a responsibility to Mr. Gilman to adequately represent this client, and you don't do that when you repeatedly fail to show up for hearings. Now, failure to calendar by an office manager. Now, that's an interesting question, and if I may approach, we filed with the court yesterday documents for this hearing, which I have a courtesy copy I'd like to provide to the court.
All right.
May I approach?
Yes. Mr. Flangas, Mr. Busby has argued that the excuses set forth in your, and that's his phrase, excuses, lack merit, that this has been going on for months, that you waited until the last moment to address the issues, that your assertion that you were spending a significant time in preparing for an arbitration belies the other excuses, indicating that you, in fact, were able to work, but spent that effort on another case or other cases other than this case. He got to the office manager, and he's now handed me a document he says filed yesterday. I have not seen this until just now. The title is Documents for Order to Show Cause, hearing scheduled for July 16, 2021. Go ahead, Mr.
I did provide a courtesy copy of this by email to Mr. Flangas, and I also mailed him a copy yesterday.
He says that he emailed a copy of this document to you, Mr. Flangas. Did you receive this?
I'm looking right now, Your Honor. I was preparing for this morning and checked email today.
All right.
Let me look.
But he hasn't had a chance to review it, so go ahead, Mr. Busby.
Your Honor, basically, these documents are a series of exhibits that show that the explanations provided by Mr. Flangas are inconsistent with the facts. Exhibit 1 is an email I received from Flangas' office showing awareness of a duty to respond to the interrogatories. Now, this was back in May. It's Exhibit 1, and it states from Mr. Flangas' secretary, copied to Mr. Flangas. I tried to reach you 3 or 4 times today by phone to relay a message to you, but your phone has been disconnected. This has occurred before when I have tried to contact you before. I wanted to let you know that Mr. Flangas is out of town. He had to go to a funeral in Italy. The priest was accompanying him. He will respond to the discovery next week and will also be filing a limited opposition in this matter. Okay. If Mr. Flangas communicated to his assistant that he was going to respond and file a limited opposition on May 13th of this year, then ignoring the previous order of the court, the subsequent orders of the court, makes no sense. His claim that it was in his calendar, that he wasn't aware of it, is inconsistent with the facts, and it directly bears on the #1 factor in Young v. Johnny Rivera, which is willfulness, the degree of willfulness involved in the violation. And willfulness means the voluntary, intentional violation or disregard of a known legal duty. That's from Black's edition 7. Mr. Flangas cannot argue in light of this message that he was unaware of his legal duty to respond. arguing that in any case, in light of the numerous pleadings and documents he received, the need to confer letter makes no sense. This was an intentional disregard of a known legal duty to respond not just to our interrogatories, to a court order, and then now to a motion or an order to show cause from the court. We have received interrogatories, as indicated, Your Honor. I received them by email at 3:50, approximately 3:50 p.m., the day before the order to show cause here. And if I may approach, Your Honor, I'd like to provide you with a copy of this. Yeah, Your Honor?
Yes, Mr. Flangas, he has argued that the Exhibit 1 to the documents that he's just provided to me, Exhibit 1 is an email from your assistant, apparently, to Mr. Busby, indicating that she had tried to get in touch with Mr. Busby, was unable to, has had that problem in the past. She indicated you had gone to Healy for a funeral, that you were going to respond next week. This was sent on May 13th, 2021. You were going to respond to the discovery the following week, and that shows that you had knowledge, you were aware of your duty, and failed to provide answers to the interrogatories or responses. He's now handed me a document entitled Defendant Lance Gilman's Response to Plaintiff Sam Toll's first set of interrogatories that he says he received at 3:50 yesterday? Approximately 3:50 p.m. yesterday. Go ahead, Mr. Busby.
Your Honor, that...
May I respond to these, or do you want to wait till the end here?
We're gonna go through them all together, so I'm gonna let him finish and then I'll come back to you.
Well, Your Honor, I would like to object to any more of these documents coming in other than emails between myself and him. The rest of these, I just took a quick gander, are not relevant to the proceedings here today. And I would only ask that he keep it to the 2 emails between myself and his office.
Like I said, this is the first time I've seen it, so I'm not sure what's in here. So I'm not gonna rule on the objection at this point. Go ahead, Mr. Busby.
Thank you, Your Honor. Now, the course of proceedings element, and just at the outset, in analyzing the factors in your deal, it's not a checklist. You don't have to meet all of the factors in order to have a case ending or case terminating sanction be issued by it. It's the factors to evaluate and weigh in the court's judgment the seriousness of the violation that's occurred. So the willfulness violation is quite clear by the email presented and by the record before the court. There's no reasonable argument that there was a legal duty that was ignored. Okay, now, the course of proceedings factor. Now, Mr. Flangas made several representations about his character and reputation when it comes to these matters. And I'm not attacking his character, but in analyzing the facts, including his past conduct and Mr. Gilman's past conduct, when faced with similar situations, what Mr. Flangas said is inconsistent with the facts. Now, if you look at Exhibit 3 to the document submitted to the court, that's an email from Mr. Flangas requesting until July 9th to respond to the interrogatories. Okay, I didn't receive them until yesterday, the day before this hearing, at late in the afternoon, before I could reasonably prepare a response or submit them in a pleading to the court. Exhibit 4 is a Supreme Court docketing statement in case number 82152 with an attached order from the Washoe County District Court in Mr. Gilman's divorce case. Now, in that case, the court found that Mr. Gilman made disclosures that were incomplete, inconsistent, and misleading. He had different counsel in that case, and this document was filed with the Supreme Court by his other counsel. But in Exhibit 5, you'll find an order dismissing Gilman's appeal in the underlying SLAPP case, in which Mr. Flangas ignored an order from the Supreme Court to file an appeal bond. And in response to that, the Supreme Court dismissed that appeal. In Exhibit 6, you'll find an October 23rd, 2017 order by Judge Russell in this court, in docket number 16OC0001018, compelling Mr. Gilman to respond to interrogatories where he completely failed to do so. His counsel in that case is the same counsel here. This is not a one-off, odd circumstance. This is a pattern of conduct. And all of these orders are, the court can take judicial notice of. They're public records. They're official government documents. They're entirely admissible, and they're entirely irrelevant because Mr. Gilman's counsel opened the door to the question of his past conduct and whether he's ever had a situation happen like this before, and clearly he has.
Let's stop there. Mr. Flangas, Mr. Busby has referred to Exhibit 3, which is an email from you to Mr. Busby dated July 1st, 2021, indicating that you are asking for a courtesy extension to July 9th without further action being brought in the interim. Exhibit 4 is a Supreme Court general information, including a warning that indicates there were issues with your handling of that appeal. Exhibit is the notice of entry I missed in Exhibit 6 tab, I think. No?
Your Honor, there's an exhibit list within some of the exhibits here because they're part of the document statements from the Supreme Court. But if you go to the very end, it's a very brief order from Judge Russell in the District Court case.
Okay. And documents from Mr. Gilman's divorce that you handled for Mr. Gilman.
I'm sorry, Your Honor, just to be clear.
Your Honor, I didn't handle the divorce of Mr. Gilman.
I'm sorry,
It was a different attorney who handled the divorce.
it was a different attorney that handled the divorce.
And I object to that even coming into the record, Your Honor, or anything. It's completely inappropriate for these proceedings.
How is this relevant if it wasn't Mr. Flangas representing him in the divorce?
Because it shows that the pattern of behavior includes Mr. Gilman as well. In that proceeding, in Mr. Gilman's divorce proceeding, the court found that Mr. Gilman had filed disclosures in that case that were incomplete, inconsistent, and misleading. Therefore, Mr. Flangas' representation that it's all him, his client had nothing to do with it. Well, there's evidence that that's not the case. And I want to address this exhibit later on, Your Honor, as well, when we discuss the responses to the interrogatories that were provided, which I'd like to do as we reach those relevant factors in the joint examination.
All right.
All right, so another factor that's relevant here is the overall participation in discovery. In addition to failing to respond to our interrogatories, Mr. Flangas has not provided any Rule 16.1 disclosures in this matter. And this case has been going on for months and months and months. We filed our separate case conference reports, and no 16.1 disclosures have been filed. So the claim of this is not willful behavior. It's completely inconsistent with the facts before the court. And Mr. Flangas' past conduct in front of other courts. And this is also something that's been happening in this very case. When we filed our complaint in this matter, there was no response. We had to file a notice of intent to take default. Only after that was a response filed. When we filed our request for exemption for arbitration, there was no timely response. They responded some 16 days later, and the required response is within 5 days. These are not isolated incidents, Your Honor. The claim of non-willfulness is inconsistent with the facts. And now, turning to element number 2, the extent to which the non-offending party would be prejudiced by a lesser sanction. Okay. Well, at this point, Your Honor, I'd like to turn to the substance of the interrogatory responses we were provided with by Mr. Gilman. And I'll try and make this as brief as possible, Your Honor, and that the court court's time is precious. There's no response at all to interrogatory number 8. And interrogatory number 13, we requested, please identify all jewelry, appliances, works of art, tools, home furnishings, electronic equipment,
Your Honor.
including sound, visual.
What you can tell them, I'm objective, and going through all those exhibits that are attached to his motion, or to what he served last night. Again, they're not germane to these proceedings at all. The only thing germane to these proceedings are my 2 emails. The rest of this is just that, his family law case has no bearing on this whatsoever. And quite frankly, it's just another further attempt to embarrass myself and Mr. Gilman. Your Honor, I would at this time ask that you rule on the objection on letting these other documents come in, because they're not really being offered for anything in this, in that. And furthermore, Your Honor, I heard that he was going to start talking about the interrogatories. After the sharing, I was going to ask that those interrogatories be for attorney eyes only, because they list Mr. Gilman's assets on there and a lot of other things, and we don't want them to be disclosed publicly. Mr. Gilman has been in Northern Nevada a number of years, has significantly contributed to the economic development of Northern Nevada, Reno, Story County. He doesn't need to have all his personal data being put out there in the general public, which Mr. Toll's apt to do. And so I would ask that any reference to any of these interrogatories not be made on the record. And at the conclusion of the hearing, Your Honor, I'm going to look forward that you want a written motion on it, that there be a protective order in place, that these not be released to anybody other than the attorney and the courts.
The argument for the document's relevance is that it shows, it's a response to your argument that there hasn't been a history of misconduct in other cases. Mr. Busby is arguing that these show that Mr. Gilman has a history of not complying with the rules. The objection to the exhibits in the documents for order to show cause that was filed, I guess, yesterday, is overruled. Regarding the interrogatories, the argument is, I want to make sure I understand, Mr. Flangas, you're not saying he can't argue those to me now. You want the answers to the interrogatory sealed after the hearing. Is that correct?
Well, yes and no, Your Honor. I don't want him mentioning what's in those interrogatories other than if he wants to make a general statement about it. Also, Your Honor, as to those documents, supposedly my misconduct, I have taken full responsibility on this. As to Mr. Gilman's his thing in those other cases, again, I'm the one who did it, not Mr. Gilman. So this isn't about Mr. Gilman, this is about me. Furthermore, Your Honor, those emails, the way he's misconstruing them, the one email that he has directly from me, I sent it on the morning of the, when I got complete wind of it, and I sent it to him. He didn't respond to me all day. Your order to show cause came in a couple hours later after that, so that email became essentially moot. And then Mr. Busby, who we did put in his return email, wrote me back and said that we'll just see how the court's going to go with the order to show cause that came down. So that's really should even be in for any type of thing whatsoever. The email left my secretary out of the way of the funeral yet. And quite frankly, she wasn't authorized to reach out on it, but that's my internal problem. And I've already taken full responsibility for everything that has occurred in this case. I've made it very clear I had a lot of problems in my office and with myself since the beginning of this year. And if Mr. Busby wants to talk about the additional motions, I don't mean to get, getting into the weeds on this, but in the underlying motion, underlying action on this case, we were supposed to have an evidentiary hearing scheduled in December 2018. That evidentiary hearing, about 3 or 4 days before that evidentiary hearing was to go into place, my father went into hospice, and my associate at the time called to see about a continuance, and Mr. Busby forced upon me to put an affidavit in the report that my dad was on his deathbed, who did die 2 days later. So if he wants to talk about additional work being foisted upon folks, that's the kind of thing that he's been doing in this case, in the underlying case. But Your Honor, I submit to the court, this is my fault. It doesn't rise to the level of a case-ending sanction, and I would object to any further reference to these documents because they're not relevant to anything in here. And again, I have come clean, I've bared my soul, and I'm the one that did this.
So I want to get back to where I think we should be, which is, this hearing is on an order to show cause for Mr. Gilman to show why he should not be held in contempt. Mr. Flangas has taken full responsibility for it. That was not sworn testimony. So one question is, we're out of time today. I've got a law and motion calendar that has to start at 10 o'clock. If you want an evidentiary hearing on that, then we'll set an evidentiary hearing on that. But it seems to me that if Mr. Flangas is to be believed, that there's not an indication that Mr. Gilman willingly failed to provide the interrogatories, the responses to the interrogatories. The prejudice, I haven't, and you just kind of started into that argument. Tell me why an award of attorney's fees in order for, you've got, I guess, some responses to interrogatories, some you don't think were complete. You said number 8, there was no response at all. Right. That complete